All right, so what we are going to talk about, despite earlier technical difficulties, is we're going to understand how they are taking away black voting power. How they're taking away black voting power. We are under assault. Our right to vote is under heavy assault and attack. I need to share with you how they're doing this. I need to show you how they're doing this using the law, how they're using the law to attack our voting rights. I must share this information with you. So stay with me right after this message. Make this work. All right. Just let me know in the comments if you can hear me. That's the most important thing. Can you hear me? All right. Please, someone give me a confirmation that you're able to hear me. We're going to talk about understanding right. Okay, got a message. No sound on the introduction music. I got that, but what about hearing me? Do you hear me okay? Do you hear me okay? Okay. All right. So I got two yeses. Very good. Excellent. I sincerely apologize for the technical issues. We typically don't have those, and wow. But you're going to get this work. You're going to get this information. I got some information to share with you that is extremely important for the African American, Afro or African American Black community. Very, very important information. All right. All right. Very good. I got confirmation from Miss Peggy Lopez that I'm being heard well on YouTube, and I think I'm being heard also on Facebook. That's what matters. So, how are they taking away black voting power? How is that happening? How are they using the court system and the state legislatures? How are they using both to take away black voting power? Well, there are two things that they're using. All right. They're using voter suppression and they're using racial gerrymandering. Voter suppression, which takes away our ability to vote, and racial gerrymandering takes away our voting power or our voting strength. Two different things. They attempt to accomplish the same thing, that is to silence our voices, but those two different methods work two different ways. Again, voter suppression, that's those laws back in the 60s. It was poll taxes and grandfather clauses and counting jelly beans in a jar. That was to prevent black folks from voting. Well, in addition to that, nowadays are the racial gerrymandering methods that they're using. And it's the racial gerrymandering methods that they're using that I want to talk about today, because there is a case that has been in the court system out of the state of Alabama that is an extremely important case, not just for Alabama, but for Black voters across the country. And I'm going to explain it to you today why this case is such an important case. Okay, such an important case. So hopefully technology will work with us going forward. So let's begin to get into this. Okay. Now I'm going to change screens, or at least that's what I want to do here. I want to change screens. Okay, that worked good. All right, very good. So we're going to look at an Alabama case. We're going to look at an Alabama case that could have national implications, national consequences. All right, here's some background facts. Alabama violently imported many Africans from their homeland and brutally enslaved them. Now, I'm going back and giving you some context about the state of Alabama, about the South generally, okay? I need you to understand contextually what it is that we are confronted with here, all right? So Alabama is one of many states in the South that imported Africans from their homeland and then brutally enslaved them and under the law made them chattel property, essentially. Now, Alabama fought in the Civil War to preserve the institution of slavery. So I'm trying to establish that Alabama is no friend to African American people. It brought Black folks over here from Africa and enslaved those Black folks. And then it fought in the Civil War to preserve the institution of chattel slavery. 45% of Alabama's population in 1866 were enslaved Africans, and their work was the basis of Alabama's economy. So 45%, almost half the population in the state of Alabama in 1861, just a few years before the Civil War began, Blacks, Africans, made up almost half the population of the state of Alabama. Now, after resisting the abolition of slavery, Alabama fought hard to preserve de facto slavery through Jim Crow or Black Code laws. All right, let me explain that. So when the 13th Amendment abolished slavery, the 14th Amendment gave us citizenship and due process and equal protection rights. Then the 15th Amendment was added, which also basically said that our right to vote should not be abridged. Later on, the Voting Rights Act was passed about 150 years later because the 15th Amendment just saying that our right to vote should not be abridged had no teeth whatsoever. So the Voting Rights was later, the Voting Rights Act of 1965 was added later to give teeth to the 15th Amendment. All right. So although slavery had been abolished by the 13th Amendment, Alabama was one of those southern states that still fought to keep African Americans basically enslaved, but by another name. And so Alabama passed Black Code laws, Jim Crow laws, to essentially keep the newly freed Africans in the same situation they were in during slavery, right? No longer chattel property under the law, now citizens, but second-class citizens, even third-class citizens, okay? Alabama was a part of that regime along with Mississippi, Louisiana, South Carolina, Georgia, Florida, those southern states. Now, prominent in Alabama's Jim Crow laws were efforts to stop African Americans from exercising their 15th Amendment right to vote using voter suppression. And remember, I said voter suppression are the efforts that the states use to take our right to vote away from us. Whereas racial gerrymandering, and I'm going to talk about that in just a moment, is intended to dilute our voice, our votes, and you could say our voice. All right, and Alabama also violently suppressed the black vote using water holes and dogs and police-involved terrorism. The KKK. Alabama was one of the most notorious states for using violence. When you see the water hoses, that's in Alabama. When you see pictures back in the 60s of the water hoses being unleashed on blacks, that's Alabama. When you see the dogs, the German Shepherd dogs being sicked on blacks who are trying to vote, that's in Alabama. When you see Reverend C.T. Vivian getting punched in the nose by Sheriff Jim Clark, that is in Alabama. When you read of the 4 little girls being murdered in the church bombing in Birmingham, that's in Alabama. Okay? I'm just trying to show you that Alabama is an extremely racist state. It is a Confederate state, and they have fought hard to prevent us from voting. And that fight continues up until this moment. They never stopped. They never gave up. They never relented in their efforts to keep us from voting. Alabama's defiant commitment to the Confederacy and anti-blackness is blatantly articulated in its state flag, which obviously resembles the Confederate flag. So anybody looking at this flag know that it is basically established on the Confederate flag. You don't see the bars and stars and the colors are different, but it's still the Confederate flag. This is literally Alabama's state flag right here. That tells you a lot. That speaks volumes. Okay? So today, rather than using dogs, water holes, church bombings to stop blacks from voting, Alabama state officials attempt to dilute the black vote using a practice called racial, or a practice called gerrymandering. Gerrymandering is a process of drawing voting districts using new census population data. So, every 10 years, the U.S. Census Bureau does its population determination. Try to see how many people in the country, try to see whether or not, a state has grown or has decreased in population. And once that information is ascertained, that information is given to state legislatures and they have to draw their voting maps. And their voting maps are based on whatever the U.S. Census says about their population. And by the way, that tells you when the census does its 10-year assessment, population assessment, it's extremely important that we participate, right? Don't, close the door on the census worker. Answer those questions so that they will have an accurate number of African Americans in your state. Because if your state's population decreases, then that's going to or could result in your state having less representatives in Congress. And if it has to decrease those representatives, chances are it will be a representative from a majority black district. All right, so it's very important that you participate in the Census Bureau when they're doing their population count. So again, gerrymandering is a process of drawing voting districts using new census population data. Racial gerrymandering, therefore, occurs when states draw voting districts to dilute the voting strength of a particular race, for example, African Americans. So when they draw those maps up, because the GOP control many of those southern states, in fact, all the southern states, right? I think every one of them is controlled by the GOP. They draw maps to give Republicans the advantage. to give, let me be more specific, to give whites the advantage and to disadvantage blacks. And that's precisely what happened with Alabama. And by the way, that happened here in Texas. That also happened in North Carolina. That happened in Florida. That's why I'm talking to you about this, because again, our voting rights and power are under assault by the GOP. We go to work every day as African-American people. We work hard, we go to work, we come home, we watch the game, we do what we do. And oftentimes we are not conscious or cognizant, understanding, knowledgeable about what is happening in the state legislatures of our states and in the U.S. Congress and in the voting precincts. They are viciously attacking our voting rights. Viciously. I mean, unrelentingly attacking them, using racial gerrymandering. But also, let me digress a moment and talk about how they also use the U.S. Supreme Court. I'll come back to this screen in just a moment. But let me share with you what happened in 2013. Let me get a little water. 2013. Let me see. Let me share this with you, and then I see that I got it scheduled I'm scheduled to talk about it here in about 10 or 15 minutes. But let me just go on and give you this information. So in 2013, the U.S. Supreme Court handed down an extremely important case. Shelby County versus Holder. Shelby County versus Holder. And in that case, the U.S. Supreme Court essentially gutted the Voting Rights Act of 1965. Now, let me explain how they did so. And let me explain the purpose of the Voting Rights Act, because it's the reason why we're seeing all the racial gerrymandering now. All right, so the Voting Rights Act was passed in 1965, signed into law by Lyndon Baines Johnson. Shout out to President Johnson for signing that law, for signing that piece of legislation into law. Okay. Now, there are two sections, or there were two sections, still are, but one has been invalidated, and they're trying to invalidate the other one with this Alabama case. But there are two sections in particular that are extremely important in the Voting Rights Act. That's Section 2 and Section 5. Now, let me talk about Section 5 for a minute. Section 5 requires that those states in the South who are notorious, who have a history of voter suppression, it requires those states to contact the Department of Justice before they make any changes to their voting laws, because the Justice Department needs to take a look at whatever law they want to change because of their history of voter suppression. That is Section 5 of the Voting Rights Act, right? It requires, again, states, specific states, not all states, those states that has that history of voter suppression. It requires them, when their legislature drafts some law, voting law, they have to send that law to the Department of Justice Civil Rights Division, and the Department of Justice has to approve it before those states can implement or enact that law. Because again, those states are infamous about having laws in there that, again, are intended to take away our right to vote. That's Section 5 of the Voting Rights Act. However, Section 5 depends on Section 4 of the Voting Rights Act. Section 4 has formulas in it that are used to identify which states and under what circumstances those states must get pre-clearance. All right, so I don't want to confuse you. Section 5 is what requires those states to get pre-clearance from the Justice Department. However, Section 5 requires only those states that Section 4's formulas identify as problematic states. Now, the Shelby County v. Holder case was the case where the U.S. Supreme Court said that Section 4, the formulas, were outdated and were no longer good. Chief Justice John Roberts wrote that opinion and said essentially that we're living in a new day. This was 2013, so this was right after Obama had been reelected. And so he used that occasion, he used the fact that blacks had elected a black man and reelected him to essentially say, we don't need to monitor these southern states anymore because clearly black folks are voting in record numbers to the point that they've been able to elect a black man and get him reelected. So why do we still need the Voting Rights Act anymore? And of course, it was the late Ruth Bader Ginsburg who wrote the dissenting opinion, arguing basically that the Voting Rights Act was basically like an umbrella that had protected African Americans from the storm. And if you take away the umbrella, the storm is going to begin to hit them again because it never left. The storm never left. In other words, the voter suppression efforts of those problematic states never stopped. They continued to try to prevent us from voting. And if you remove the thing that protects the African American voter, then the racial gerrymandering and the voter suppression and all the stuff that they are notorious for doing will begin immediately. That was what she wrote in her dissenting opinion. Yet John Roberts, Chief Justice John Roberts, along with the other conservatives on the court, disregarded that and said that Section 4 was outdated. There need to be some new formulas because the states that the formulas identified no longer needed that sort of monitoring anymore. That's the Shelby County versus Holder case. It essentially knocked the Voting Rights Act, it knocked one of the legs out from under it, okay? So that happened 2013. Guess what happened the very next day? That case was handed down on one day. The very next day, Texas, North Carolina, shortly thereafter, Florida, Alabama, changed their laws to restrict black voting rights, like the very next day. Exactly what Ruth Bader Ginsburg said happened. Exactly. And because they gutted Section 5, that's why we're seeing the stuff that we're seeing now, because they no longer have to get clearance. They no longer have to submit their proposed voting laws to the Justice Department anymore. So they're able to basically do what they want to do, except for Section 2 of the Voting Rights Act. So Section 5 has been invalidated because Section 4 was invalidated, but that left Section 2. All right, I'm gonna come back to Section 2 in a moment. All right, let's go back. I hope you understand that. If you got questions, if you didn't understand what I just said, put them in the comments. I will be happy to get to them. I don't know if you're getting what I'm saying. I don't know if I'm speaking too fast. I don't know if I need to give you more information or what. Just let me know. All right, now let me go to another screen. Okay. So Alabama, after the 2020 census, Alabama drew up a voting map, which consists of 7 districts. 7 districts. Only one of those districts was a majority black district. Although 27% of Alabama's population is black. All those black folks that they brought from Africa and at one time made up 45% of Alabama's population, those blacks didn't go anywhere. They're still there. And now that because they're still there, Alabama is doing everything it can to try to tamp them down and keep control of them. So they drew up this racist, gerrymandered map that essentially dilutes the voting strength of black people. Because think about it, 27% of something is almost a third. That's almost a third. It's more than a quarter. And 1 out of 7 is not a quarter. So that on its face was discriminatory. So black people in the state of Alabama sued the state and said, this is not right. There should be at least 2 majority districts, 2 black majority districts on this map. You all got only 1. So you're trying to dilute our voting power. In other words, with this 1 black voting district, we will have only 1 African-American representative in Congress. We should have 2. But that map did not give them 2. That map gave them only 1. So the blacks in that state sued the state of Alabama. Okay, now let's go over here. Let's go over here to the background facts. According to several federal judges, Alabama engaged in racial gerrymandering in 2021 using the U.S. Census 2020 population data. Alabama drew a voting map that has 7 districts. 6 of those voting districts were majority white and 1 was majority black, just as I explained. The federal judges found this map likely violated Section 2. Remember, Section 5 is invalidated at this point because the court invalidated Section 4. Section 5 can't work without Section 4, basically, because Section 4 tells Section 5 which states that it needs to require preclearance. So when the court got rid of Section 4, it essentially got rid of Section 5, the preclearance clause of the Voting Rights Act. So that only left Section 2, and Section 2 doesn't have the teeth that Section 5. Section 2 does not require preclearance. It just looks at, whether there is discrimination. Section 5 went further than that. Section 5 said you got to get approval from the Department of Justice before you do anything with your voting laws, because we know what you'll do. The history tells us you are notorious for trying to make sure blacks don't vote. I mean, you've unleashed dogs on black people, trying to keep them from voting. You've put water holes on them. The KKK, your police officers. We saw police officers beat the late Representative John Lewis and many other blacks on the Edmund Pettus Bridge who was simply trying to register to vote. So states like Alabama was notorious, but when Scotus gutted the Voting Rights Act by getting rid of Section 4, which invalidated Section 5, that left Alabama in a place to do a whole lot of stuff. and they did it. Georgia, remember just a couple years ago, Georgia passed laws that says you can't bring people water if they're standing in a voting line. It cut the number of early voting days. It limited the places where you could drop off your ballots. All kinds of things that would have never happened had SCOTUS not invalidated Section 4 of the Voting Rights Act. That would have never gotten approved by the Justice Department. So that was a big step in their voter suppression efforts when the court dialed back Section 4, dialed back the Voting Rights Act. All right, so the federal judges found that this map likely violated Section 2 of the Voting Rights Act because African Americans comprise 27% of Alabama's total population. So that means, and basically, as I said, out of the 7 voting districts, there should be at least 2 black majority districts in Alabama. So those judges said, no, this map, the 2021 map of Alabama, is unconstitutional. Alabama appealed, and the United States Supreme Court issued what's called writ of certiorari, allowing the case to come before the court. So the case went before the court. All right. SCOTUS affirmed the lower court and ordered Alabama to draw another map that has 2 majority black voting districts. So surprisingly to everybody, right, those 6 conservatives did not agree with Alabama's map and said, hey, this does violate Section 2. So you got to go back and draw a map that has 2 majority districts. We agree with the lower federal court in Alabama. You got to go back. You got to correct this. That was a shock. That was a shock to everybody who keep up with this, right? There's no way the 6 conservatives on the U.S. Supreme Court, anyone expected them to agree with those judges and with the blacks. No way. But they did. Okay? They did. And told Alabama to go back, redraw your maps, and give blacks 2 majority voting districts. Well, as you see here, Alabama defiantly refused both courts' rulings and drew a 2023 map that still has only 1 majority black voting district. Now, take a deep breath. I want you to understand what I'm saying here and what has happened. So SCOTUS surprisingly said to Alabama, no, you got to go back and you got to do what the lower judges told you, draw a new map with 2 voting districts that are majority black. Alabama went back and basically said, forget you, SCOTUS. We're going to draw another map, and it's still going to have just 1 black majority district. And that's what they did. So those black plaintiffs in Alabama sued the state of Alabama again. And once again, the lower federal court said, what didn't you understand? We told you that 1 black majority district in the state of Alabama likely violates Section 2 of the Voting Rights Act. So why are we here? Why are we here? So I want to now look at the case a little bit here. There's some language in here that I want you to see. All right, let me pull it up. Let me try to pull it up. If everything works the way it should work. All right, everything works the way it should work. I want to pull up this case, and I want you to read some of the language. I'm going to show you why this is important, not just for Alabama, but for every African-American voter across the country. Stay with me. Okay. Let's see if this works. Y'all just forgive me. I'm the presenter, the producer, and everything. Okay, so I'm doing the best I can. Wow, it doesn't look like it is going to work for me. But there's another way to skin a cat. Just hang on. Okay, just stay with me. This might do it. No, it didn't. So let me try something else. Let me try something else. Let me just see what happens here. Don't you go anywhere. Don't you dare go anywhere. I'm empowering you with information that is needed. Let's see if this works. Okay, this worked. So 2 ways, more than one way to, well, I won't use that euphemism. It's probably offensive. Anyway, here is that federal court, 3 judges on this federal court. You see right here, it says 3-judge court. And I highlighted some of the language. So they wrote in this opinion, these congressional redistricting cases have returned to this court after the Supreme Court of the United States affirmed in all respects a preliminary injunction this court entered on January 24, 2022. So the court says, here we are again. Here you are back in front of us after the Supreme Court affirmed everything that we told you. And here you are back again in a little bit, about a year and a half, back in front of us. I mean, why? So they go on to say, after an extensive 7-day hearing, this court, we concluded that the 2021 plan likely violated Section 2 and thus enjoined. The word enjoin means stop. We prevented you from using that map because Alabama wanted to use that map, right, in its voting. But they said, no, we enjoined. We stopped the state from using that plan in the 2022 election. Okay? Based on controlling precedent, we held, in other words, they're about to say what they ruled then. We held that the appropriate remedy is a congressional redistricting plan that includes either an additional majority Black congressional district or an additional district in which Black voters otherwise have an opportunity to elect a representative of their choice. We observed that, quote, as the legislature considered remedial plans, it should be mindful of the practical reality, blah, blah, blah. You don't have to read that. But they are basically scolding the state of Alabama. I mean, it's like when your child, you are clear, you're very clear, do not do this. And they turn around and do the very thing that you told them not to do. They were scolding the state of Alabama like that. Okay? So they're going to say, on June 8th, 2023, the Supreme Court affirmed the preliminary injunction. The Supreme Court saw no reason to disturb this court's careful factual findings. In other words, the court agreed with us because we carefully had that hearing. We heard all the evidence. We let you put forth your case. Everybody had their day in court. Our judgment was sound, and Scotus agreed with us. All right? which are subject to clear error review, which basically means that their opinion was subject to what's clear error. In other words, the Supreme Court would not overturn it unless there was some clear error, and have gone unchallenged by Alabama in any event. Likewise, the Supreme Court concluded there was no basis to upset our legal conclusion because we faithfully applied Supreme Court precedents and correctly determined that under existing law, the 2021 plan violated Section 2. So they're like, why are we here? Scotus agreed with us. We knew we did our homework. We studied the issues, we crossed the T's, we dotted the I's. Why are you back before us with the same type of plan that we and Scotus already told you doesn't work? And by the way, this is a 3-judge panel. 2 of them were Trump appointees. This was not a Democrat-controlled panel of judges. 2 of them were Trump appointees. And even they said, no, this is pure racial gerrymandering. All you're trying to do is dilute or weaken voting power of Black Alabamians. And we're not having it. And the Supreme Court, even the Supreme Court, which is also controlled by 6 conservatives, 3 of which, I think, Trump appointees, Amy Coney Barrett, Neil Gorsuch, and Kavanaugh. 3 of them are Trump appointees. And even they said, and by the way, I didn't do something. Let me go back and do something else. What you also may not know is those 6 conservatives have spent their careers fighting voting rights. All 6 of them. John Roberts worked in the Reagan administration fighting voting rights. Clarence Thomas worked in the Reagan administration fighting voting rights. Sam Alito, fighting voting rights. Neil Gorsuch, fighting voting rights. Amy Coney Barrett, fighting voting rights. Brett Kavanaugh. In other words, these folks are committed to stopping Black people from voting. They have used their law degrees for that purpose specifically. Some of them did some private practice and so on, but they sort of cut their teeth in the Reagan and Bush administrations fighting voting rights. So I'm not making up. I'm not, using hyperbole here. I'm telling you, I'm warning you that as African Americans, our rights to vote hang in the balance. Literally hang in the balance. Now, let's read a little more. On July 21st, 2023, the legislature enacted and Governor Ivey signed into law a new congressional map, the 2023 map. Just like the 2021 map enjoined by this court or stopped by this court, the 2023 plan includes only one majority Black district, District 7. So they are belaboring the point. Why are you here with another map that we already told you violates Black Alabamians' right to vote, and it dilutes their voting power? Why are you back in front of us? And I'm going to tell you why in just a minute. The state concedes, in other words, they admit that the 2023 plan does not include an additional opportunity district. Indeed, the state has explained that its position is that notwithstanding our order and the Supreme Court's affirmance, the legislature was not required to include any additional opportunity district in the 2023 plan. So they said, forget what y'all said, forget what Scotus said. We don't have to do that. We don't have to obey that. We don't have to follow that. We don't have to do what y'all say. We're a sovereign state. I don't know. That's the way it appears. I mean, because typically when SCOTUS decides something, it's decided. It's over. It's done. States typically don't buck SCOTUS like that. I mean, that's a linchpin of our republic, that the Supreme Court says what the law is, and as the third branch of the government, they basically interpret the law and decide cases and controversies. And that's that. There's no one else to go to. That's it. Over. Not with Alabama. And it's not just Alabama. Let me show you one other thing here I want you to see, I believe. One other thing. We have reached these conclusions only after conducting an exhaustive analysis of an extensive record under well-developed legal standards, as Supreme Court precedent instructs. So they're belaboring the point. They're like, look, listen, folks, we conducted an exhaustive analysis based on an extensive record under a well-developed set of legal standards that SCOTUS enunciated. We do not take lightly federal intrusion into a process ordinarily reserved for the state legislature. That's real important. What they're saying there is, like you, Alabama, we're conservative and we believe in states' rights, and ordinarily you would have won this fight. But this was so glaring that even we had to set aside states' rights and apply the federal standards here. That's what they're saying. But we have now said twice that this Voting Rights Act case is not close. It's not close. I mean, this is not this is not even. This is not. You got 20 and they got 21. This is you got 2. And it's like it's like the victory that Primetime had yesterday over Nebraska, or the Colorado Buffalo. I mean, what they have 30-something points, and right into the fourth quarter, Nebraska had 7. I mean, it wasn't even close. So this is not even close. If it was, we would have given it to you. We're all trying to accomplish the same thing, but they're saying we couldn't. We looked at this very closely, and we couldn't give you the victory on this one. And then they go on to say, and we are deeply troubled that the state enacted a map that the state readily admits does not provide the remedy we said federal law requires. We are disturbed by the evidence that the state delayed remedial proceedings, but ultimately did not even nurture the ambition to provide the required remedy. And we are struck, listen to these words this court is using, by the extraordinary circumstance we face. We're not aware of any other case in which a state legislature, faced with a federal court order declaring that its electoral plan unlawfully dilutes minority votes and requiring a plan that provides an additional opportunity district, responded with a plan that the state concedes does not provide that district. The law requires the creation of an additional district that affords Black Alabamians, like everyone else, a fair and reasonable opportunity to elect candidates of their choice. The 2023 plan plainly fails to do so. That is a scolding. That is a scolding. That is not the kind of opinion that you want judges writing to you. They are exacerbated with Alabama. Again, it's like us as parents telling our kids to do something very clearly, and they go do the very opposite and come tell us they did the opposite. In fact, not only tell us that they did the opposite, but tell us that I ain't got to do what you said. I mean, that's what Alabama did. Now, why? That's the question. Why? Two reasons. Two reasons. This case involves the last section of the Voting Rights Act that has any teeth whatsoever. And it's weak by itself. It's weak. But it's the last section of the Voting Rights Act that makes the Voting Rights Act mean anything. Section 2. This case is based on Section 2. So Alabama, true to its heart, that's why I went through all that slavery stuff and all that Jim Crow stuff, true to its Confederate heart, is determined to see to it that Scotus guts Section 2. So they're like, we don't care what you said. Lower federal court, we don't care what you said. We want to get this back in front of Scotus because Scotus must have had a bad day that day or whatnot. These are 6 people that we have worked hard to get on this court. We have worked for 50 years to get these type of conservative, extreme, right-wing folks on this court. I don't know what was going on with them. We're not sure, but we want to get this case back in front of them again. And I'm sure, they're sure, this time, they will do what they know they're supposed to do. Because we're all right-wing, Confederate, conservative, bigoted, racist, white supremacists. We're all the same. And why they didn't do it, we're uncertain, but we're sure if we can get it back in front of them, they will finish gutting the Voting Rights Act. Because if SCOTUS changes its mind, and there's one justice in particular that they're looking at, and it's Brett Kavanaugh. I read an article where it says behind the scenes, Brett Kavanaugh and Chief Justice John Roberts sort of worked out some kind of deal. I guess they didn't want to completely just yet gut the Voting Rights Act in the same term that they gutted affirmative action. So they're like, that's a bit too much because everybody already think that we're a bunch of right-wing extremists on the court here. We're political and so forth. So we probably shouldn't do it yet. We're going to do it. It's going to get done. But it's probably not a good idea to do it in this term. So Alabama is just hell-bent on getting this case back in front of SCOTUS because it's like we don't know what was going on with you all at that time, but we're certain that you all will do the right thing this time because this is what we've all worked for, getting rid of the Voting Rights Act. Because the Voting Rights Act is the reason why we had a black president elected twice and now a black female president. And it all came about because of the Voting Rights Act. And we got a case here in front of you that will enable us and enable you to get rid of the last little piece of the Voting Rights Act and you didn't do it. We got to get this case back in front of you. We don't care what those lower judges said. We want to get this back in front of SCOTUS. And in this article that I read, they seem to think and have had some back channel communications through a friend of a friend of a friend with Justice Kavanaugh, who is now willing to re-look at this and, and this time it could go completely different. And if so, the opinion will likely totally invalidate Section 2. If they look at this again, and I'm telling you right now, Section 2 will be invalidated by this court. If not with this Alabama case, with some other case, because they're not quitting. These states are not quitting. Not only these states, these conservatives, they're not quitting. They're going to keep coming and coming and coming and coming until they got the Voting Rights Act completely gutted. And all that remains is Section 2. Now, by the way, Congress can fix the problems with Section 4 that Chief Justice Roberts said Section 4 has. Congress, in fact, he told him in the opinion, this is up to Congress to fix this. And Congress has done nothing. There have been bills that have passed the House, but the Senate, which has been controlled by, or at least has enough conservative Republicans to stop, to prevent the Senate from approving any of those laws, like the John Lewis voter. I forgot the exact name. The John Lewis Voter Restoration Act, I believe. That was the whole purpose of the John Lewis Voter Registration Act. All right, to fix Section 4. So Congress can fix Section 4, right? But the thing is, just getting it through. And doesn't all this tells you that elections matter? How did Trump get the opportunity to put 3 folks on the court? Because one of the reasons is because he was elected president, and some of that was because either some black folks voted for him or others didn't vote. And for the record, I'm not a Democrat. I'm not a Republican. I'm an independent voter. I'm not a partisan. But I, with a passion, abhor white supremacy. I abhor white supremacy because I know, we know what white supremacy is all about. We have 400 years of what racism and white supremacy has done to our ethnicity. So I abhor it. I fight it every day. So that's why I'm so adamant and passionately against this Republican Party, this GOP, these conservatives, because they're extremists. So Congress can get this done, but even then, you all, let's say Congress was able to get something passed. Then what are they going to do? They're going to sue and get it right back in front of the court again. And the court is probably going to find the new formula violates the Constitution. Because it's not really about whether it violates the Constitution. It is about white fear. White fear. Fear of changing demographics in this country. That's what it's about. And they see black voting strength increasing. And they're doing what they can to try to dilute that voting power. Right? A black president, a black female president. What's next? They're taking over the country. That's how Donald Trump was elected in the first place. Because white people, saw the handwriting on the wall. We got this black man what they're taking over this country. So what did John Roberts do? He gutted the Voting Rights Act. You see? So they are certain, Alabama's certain, we just need to get this back in front of Scotus. We know they'll do the right thing. We've all been committed. I mean, they've all worked together, right? As lawyers, they were all colleagues in the Reagan administration and the Bush administration, and so they're buddies. Again, I think that John Roberts and Brett Kavanaugh just basically said, I think they thought it would be just too much to gut the affirmative action programs and the Voting Rights Act in the same term. And by the way, I can't talk about this without talking about Clarence Thomas. What a man that is. For 30 years, he has been on that court, voting with white conservatives 99.9% of the time, hurting black folks left and right politically. It's just amazing. And, he said, I've read a couple of his books, and he says that he thinks the way he thinks because of principle, because of the way he was raised by his grandfather. Then it comes out, no, he's been getting paid by billionaires here in Texas. What? You're taking lavish trips and all that from rich billionaire, GOP, conservative, white? What? Wait, hold it. Wait, what are you doing? This is not principle. You're getting paid. Wow. Why does this matter for all of us, not just black folks in Alabama? Because if Section 2 is gutted, folks, the Voting Rights Act is dead. It's on life support now because Section 5 really gave it its teeth. Sections 4 and 5. Section 2 is so bland. So it's on life support as it is. If this case gets back in front of, if Alabama's case gets back in front of SCOTUS and they flip and give Alabama what they want and say, yeah, okay, your map is okay. Your map that has one black voting district is okay for this or that reason. Then Section 2 is over. I mean, it was already weakened by another case. I think it was in 2021, Bravanovich, the Bravanovich case where Sam Alito just took a hammer to Section 2 and hammered it. So it was weakened by that case. This one or some other one will completely get rid of it. And why does that concern me? That concerns me because then there are no guardrails to conservative extremists enacting whatever kind of law they want to enact to do away with our ability to vote at all. I mean, literally, they could say, well, you know what? Black folks, y'all not voting no more. We're just gonna stop it. We're just gonna stop you. We're gonna stop you. I mean, Vivek Ramaswamy, or whatever his name is. I mean, he's already talking about affecting the voting laws. I mean, they're on the campaign trail already telling us what they are due. This is really serious. This is really serious. And I read a CNN report that says more than 60% of the country favor any GOP candidate over Joe Biden. So one of these folks could be elected who has set their sights on doing everything possible, every anti-black thing possible. This anti-woke stuff that that DeSantis is doing down in Florida. That's all anti-black. When it comes to our right and ability to vote, our power to vote, as John Lewis used to say, it's almost sacred. It's almost sacred. If they take that from us, what can we do? We're back before the civil rights movement. All we'll have is the 15th Amendment that has no teeth. That's why we needed the Voting Rights Act in the first place. So we would be set back 70 years, 80, 90 years if they gut Section 2 of the Voting Rights Act. I mean, all kinds of things they could do. No voting on the black side of town. No, no ballots over there. You got to come to this side. Any number of things they could do. Any number of things that they could do that, and we know they would do it because there is a history of them doing it. Poll taxes. You got to pay a tax before you can vote. Grandfather clauses. Your grandfather had to have voted in order for you to vote. Count the beans in this jar. Who was the 17th president? You standing up ready to register or to vote. All right, before you can vote, who was the 16th president? Who was the wife of the 29th president? How many children did the third president? Don't think they won't do this. They already did it. So, we live in very serious, precarious times. All right. Let me go over here to some of the comments. Hello, everybody. Comments here from my dear darling wife, sweetheart, Antonia Corbett, and comments from Miss Peggy Lopez. Miss Lopez asks, are you willing to come on another program and discuss this information to reach a wider audience? Sure. Absolutely. Is the answer to that question. Ms. Lopez says the Supreme Court is bought and paid for by rich old white men. I agree. Okay. So those are some of the comments that we've gotten, and we appreciate every one of them. Ms. Lopez, thank you for commenting. So, man, that's what I needed to share with you all today. We're in a very bad set of circumstances here, and I don't see it getting any better. Quite frankly, we got 6 folks who will be on this court for many years to come, many, many, many years to come, and they are hell bent on finishing the Voting Rights Act. All right. And states all across this country are going to start doing a lot of stupid stuff to keep black folks from voting. Promise you. Promise you. Promise you. I absolutely promise you. Okay. All right. So that's going to do it. That's going to do it. that is going to do it. Thank you all so much for joining me. I'm just going to keep getting the information out. I mean, that's all I can do. I'm going to keep getting it out, keep getting it out, keep getting it out, keep getting it out. All right? I'm going to keep preaching it. All right? As an attorney, I see a lot of stuff. I'm a civil rights lawyer, and I see a lot of stuff in the law that the average African American doesn't see. And so if I sound alarmed, it's because I see storms coming. Serious storms on our way. Right? And it seems like my community is not prepared for those storms. So I'm like a watchman on the tower, on the wall. Okay, saying, hey, there's a storm brewing. We need to do something. So I'm going to keep telling it and sharing it, and you keep tuning in. If you're not a subscriber, if you like what you heard, please go to our channel, subscribe, like, share, comment, click the bell so you'll get notified when we do these videos. We try to do one or two a week, at least one or two a week. I got several more coming. I'm getting ready to critique PragerU, this right-wing organization that's trying to weasel its way into Texas schools. It has already weaseled its way into, well, it didn't weasel its way into Florida school. It was invited with open arms. And you need to know, if you got, my kids are out of school. If you got small kids, middle school, elementary kids, high school kids in Texas schools, Florida schools, as an African American, you don't want them hearing the spin that PragerU tends to put on what it calls history. I'm going to be doing that video soon. And if you click the bell, you get notification of it. But anyway, thank you for tuning in, and I'm out. Peace.